Joe Biden and Kamala Harris have vowed to take away your Second Amendment rights through gun bans, gun confiscation, and government regulations. Now, Joe Biden is no longer hiding his real intentions, and we need you to take action now.
Whether it's a 9mm pistol or whether it's a rifle is ridiculous. I'm continuing to push to eliminate the sale of those things. But
the Biden administration is coming after your right to own any gun. Joe Biden has already issued executive orders.
Welcome to another edition of the Daily Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every Friday, Alex Ooley of the Ooley Law Offices in Indiana. Alex, thanks for coming by today, man.
Yeah, thanks for having me, Paul. Great to be with you.
So let's get started. What we planned on today was covering the Heller decision, with the Supreme Court taking up another Second Amendment case next week. But this ran across my my stream this morning, caught my attention, and got my got a burr under my saddle, and so I wanted to talk about this article here real quick. ABC News put up this article yesterday, and it came up to my attention this morning. Why the Second Amendment may be losing relevance in the gun debate. This is by Libby Cathy and was actually posted yesterday. I'm going to scroll past the advertisement here. I'm not going to read this thing word for word. I'm going to basically paraphrase a lot of this. What is going on with this article is it's kind of a poo-poo piece. It's a, I don't know what you gun rights people are worried about. You've got it so good right now. Why are you pushing so hard piece? And what I think this article is overlooking is New Jersey, New York, Hawaii, Connecticut, Massachusetts, where these things are not so great for gun owners and are getting worse. I wanted to go one place specifically in here and talk to you, Alex, about this, because the experts, so to speak, that they quoted in this article wrote in the Indiana Law Journal or something here, where I'm trying to find it here. Joseph Blocker, professor of law and co-director of the Center for Firearms Law at Duke Law School, described the patchwork of state laws that exist across the country as a buffer zone for the Second Amendment. Before you even get to the Constitution, there's a huge array of other laws super protecting the right to keep and bear arms, he said. This collection of laws is giving individuals lots of protection for gun-related activity the Second Amendment would not necessarily require, and certainly in almost all those instances, no lower court has said the Second Amendment would require. Alex, go ahead, man. I'm kind of at a loss for it, and my thoughts are a little jumbled right now. Go ahead, man.
Yeah, no worries. I mean, the article, even just the title, kind of raises an important point about the Second Amendment. And while I disagree with the tone and the suggestions made in the article, the title, Why the Second Amendment May Be Losing Relevance in the Gun Debate. Well, I don't think it's losing relevance, but it does raise an important issue, and that's that the Constitution provides a floor for our rights, not a ceiling. So the states can certainly provide more protection than the Second Amendment, but the Second Amendment provides a bare minimum, and states cannot provide less protection than what's provided by the Second Amendment. And that's what's so important to understand about. And thank goodness there are many states that have more protections than the Second Amendment. But with that said, there are many states, like you mentioned, that New York, New Jersey, California, Hawaii, etc., that provide almost no protection for the right to keep and bear arms. And that's where the Second Amendment plays an important role in making sure that those states that are not favorable to the right to keep and bear arms at least meet certain minimum requirements for protecting our right.
Absolutely. And journalists being so reliant on the First Amendment should be among our most ardent defenders. And yet they seem to be some of the people we have to struggle the most with in getting them to see things from our perspective. I want to get
the article. But the article makes this point too, this distinction about the judicial Second Amendment versus this aspirational Second Amendment. And where the article kind of goes astray with that is that it over the last century, basically until Heller, there were very few court cases interpreting the Second Amendment. Mm-hmm. But with United States versus Miller in the early 1900s, that case was kind of this ambiguous case, and it was really more about a restriction on a type of firearm, not whether or not the right to keep and bear arms was an individual right versus a collective right. Well, lots of activist judges around the country built upon that Miller decision and used it to say that the Second Amendment protects a collective right, not an individual right. So I think that's where the person in this article is getting at with this distinction between the judicial and the aspirational Second Amendment. They're trying to say that the judicial Second Amendment really doesn't provide as much protection as what supporters of the Second Amendment think it does. But they're relying upon these activist decisions prior to Heller that interpreted the Second Amendment that's in a way that's not consistent with the text or history of the Second Amendment.
Right. Yeah. And I just found where that was in the article, because you and I had talked about that briefly before we went to air. And this is where they go off on the attitude of, well, gun rights owners have got it so good right now. This guy Winkler told ABC News this aspirational or political Second Amendment has become the basis for expanding gun rights in the last 40 years. In the judicial Second Amendment, gun rights advocates haven't found that much protection, Winkler said. Where they found protection was by getting state legislatures, in the name of the Second Amendment, to legislate for permissive gun laws. And then I'll give them credit. The next sentence is, the Second Amendment of the United States Constitution reads in full, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And I want to take one minor little side trip here. When I was in college, I was for about a month, I was considering life in the legal world, and I took some courses in the paralegal kind of vein. And one thing I did learn is the difference between can and shall. And when a law, when specifically legally, when it says shall and shall not, that is a dead stop. There's no exceptions. So shall not, that means the people's right to keep and bear arms cannot in any way, shape, or form be infringed. That's what I learned 30 years ago when I was in a second-rate junior college and was majoring in beer and minoring in legal theory.
Yeah, that's a great point, Paul. I mean, there's this distinction, like you said, between can and shall, or may. Typically, they
may,
use the word
yes.
Yeah, may versus shall. And may, as the word implies, is discretionary. Shall is not discretionary. It's a right that shall not be infringed. It's not a right that may be infringed. It shall not be infringed. And that sort of lends itself to this case that's coming up next week for oral argument, the New York State Rifle and Pistol Association case. I mean, the state of New York has a may issue licensing scheme. So the question there is whether that may issue regime for licensing violates the shall not be infringed part of the Constitution. So do we have a right to carry firearms outside the home for the purpose of self-defense? And I'm looking forward to a favorable decision in that regard. Don't know the extent or how favorable it will be, but I believe it will be favorable.
Absolutely, especially like when you were on Polite Society on Monday a week ago, we said especially when Thomas writes the opinion. I'm please let Justice Thomas write the opinion. I want to get in some comments here real quick. Charlie Chambers says BS hit piece. Yeah, I was commenting to Alex before we went live. I cannot believe that Mike Bloomberg himself did not write that. And then he had a follow-up comment a little later. Hello from North Carolina. Going to Philadelphia in November. North Carolina has Pennsylvania reciprocity for carry permits. Can I legally carry downtown Philadelphia concealed? What say you? Charlie, I'm going to say go to handgunlaw.us. You can look at it. You can definitely find out the answer with certainty there. Put in your North Carolina license, and it'll tell you that you have reciprocity. And if there is an exception for Philadelphia, it'll give you that exception. I do not know right now. Honestly, I can't. I can barely keep track of where I'm supposed to be this evening, let alone 40, all 50 states and whose reciprocity is in what, and whose exceptions are where. So, but I do know Philadelphia has some pretty strange exceptions when it comes to gun laws in Pennsylvania.
Yeah, I would echo that advice. Handgunlaw.us is a great resource, and if it doesn't have the specific answer you're looking for, it does link to the text of the actual statute. So I think that's a great resource.
Here with Larry Benson. This is an interesting one. I don't know what you right to free speech people you want. You've got it so good right now. I don't know what all you equal right protection people want. You have it so good right now.
Well, as we know, there's a huge push, especially in social media, to limit speech. Of course, that's not government-controlled speech. The Bill of Rights protects us with respect to government action, not private actors. But there's certainly lots of political pressure for these large tech organizations to crack down on free speech.
Yeah, totally off the wall. But did you hear the apparently Facebook is changing its name to Meta across everything it owns? Okay.
I'd heard that, and I saw somebody comment, I don't know if this is true, but apparently Meta in Hebrew means dead, which is sort of ironic.
And change your name to MySpace. I think that one's open now.
Right.
Rob, we're going to get to the Heller decision here in just a second. We've used up almost half our time. Robert says they're going to have to drag New Jersey kicking and screaming. You know what? We're prepared to. My boss, Alan Gottlieb, and the SAF, we will do that. We have the power through the courts to absolutely drag Governor Murphy kicking and screaming into compliance, and we will.
Yep.
All right. Charlie Chambers. Is it meth, or Metamucil? There you go. All right. New York Artcast has an answer for Charlie. Because of the opioid emergency BS, you can't carry open in Pennsylvania unless you have a CCW in your own state that Pennsylvania recognizes. Okay. All right. Well, let's talk a little bit. The plan today, before this hit my attention this morning, the plan today was talk about Heller, because the last major Second Amendment decision. McDonald was after Heller, but the last time something hit that has the potential to change directions in Second Amendment law the way this one does was Heller. So we wanted to go a little bit of an overview of Heller and how that changed things. So take it away, man. What you got?
Yeah, so I think the idea behind talking about Heller today was just to give people some background and context for the upcoming oral arguments in New York State Rifle and Pistol Association versus Bruin next Wednesday. And Paul, I don't recall the time off the top of my head, but I know you're going to be doing some broadcasting with, is it Teresa Inack, or is that how you say her last name?
Yes.
Do some commentary about that. So if folks are interested in that, I think definitely tune in for that. I think
that will be
commentary on that.
Oral arguments are Wednesday morning, and Teresa will be joining us 5 p.m. Central Time, 6 p.m. on the East Coast, Wednesday afternoon. So everything should be wrapped up and the oral arguments all finished up, and she'll be joining us that afternoon to discuss how oral arguments went and go over the minutia of that.
Yeah, that should be really interesting. So I hope folks tune in for that, because we may be able to read the tea leaves a little bit from the questions that the justices have during oral argument. We may be able to get some idea about who might write the opinion even, but obviously there's a lot that can happen in various different permutations of how this could go, but I'm interested to hear Teresa's commentary. So with that in mind, I think, as Paul, as you said, Heller was actually, it's been over a decade since the opinion came down, and that it was June 26, 2008 when Heller was decided. And in a 5-4 decision, the Supreme Court held that the Second Amendment protects a pre-existing individual right to keep and bear arms. It's not associated with participation in the militia. It's not a collective right. It's an individual right to keep and bear arms. And this was the first Supreme Court case that really explicitly stated that, because I think as the case, and if you read the Heller case, like my dad suggested on the Daily Bullet last week, it's got a lot of really interesting history in it, and they talk a lot about the history of the Second Amendment and what it meant to keep and bear arms at the time of the founding. And it really doesn't even read like a legal opinion. It reads more like a treatise on history and political science and philosophy. So it's a really interesting legal opinion. It's not one of those legal opinions that makes your eyes gloss over.
One of the ones that I keep getting referred to is Scalia's opinion in the Heller decision.
Yeah. He provided a lot of the context and the history to the decision, and I think wrote very effectively, advocating for, not advocating, but providing a foundation for why this was seen as an individual right rather than a collective right. And as a matter of fact, I wanted to, at some point in our discussion today, to point out a fantastic quote from the case. It's actually a quote from St. George Tucker, who wrote a version of Blackstone's commentary, and he elaborated on the Second Amendment, and he said, and he was writing around the time of the founding, and he said, "This may be considered as the true palladium of liberty. The right to self-defense is the first law of nature. In most governments, it has been the study of rulers to confine the right within the narrowest limits possible. Wherever standing armies are kept up, and the right of the people to keep and bear arms is, under any color or pretext whatsoever, prohibited, liberty, if not already annihilated, is on the brink of destruction." And I just thought that was an awesome quote, and it sort of provides not only support for this viewpoint that the right to keep and bear arms is an individual right, but that it's one of the most important, if not the most important, individual rights that we have, and it's a right that pre-existed the founding of this country, the Constitution, and the Bill of Rights. So I think that really just sort of sums up the importance of the right to keep and bear arms, and sort of shows why this aspirational Second Amendment that was discussed in that ABC article we talked about earlier is so important to folks. And it's not about expanding our rights. It's about protecting this important right that we have always had. Not about expanding it. It's about protecting it and getting back the rights that we've lost in that regard. So I really thought that was a great quote from the case.
I want to get in one comment here real quick. And Larry Benson says the militia issue is a tail that wags the dog of the substantive individual right. I would absolutely agree with that. Well, what do you think, Alex?
Yeah, so I think that's a great point. I think it's important to point out that the Second Amendment has two components. There's the prefatory clause and then also the operative clause. So a well-regulated militia being necessary to the security of a free state announces the purpose of the right. It doesn't tell us what the right is, it announces the purpose. And it doesn't in any way limit or expand the right itself. Okay, so it's the preface, it tells us the purpose. But then the right itself, the substance of the right is the right of the people to keep and bear arms, and that right shall not be infringed. So what we can tell from that is that the right, when the founders wrote the right in lots of contexts, that implies that it's a right that pre-existed. It's not a right that's given to us. It's not a privilege. It's one that pre-existed the Bill of Rights. So the right, and then of the people, and the people was commonly used to refer to the whole of the people, not a particular subset like only the people who could participate in the militia or only certain groups. It was the whole of the people. And that right was the right to keep and to bear arms. And the Heller decision really goes into a lot of detail about what was meant by not only the right and the people, but also goes into this individual parsing out the language of keep and bear, and what they meant separately and what they meant together. So to keep just meant to have, and to bear meant to carry. And there's really no other way to interpret that language in the normal and ordinary sense, because if we try to say that to keep and to bear meant the same thing, like only to have a firearm in the house, then that violates a rule of construction and legal interpretation called the rule against surplusage. So you shouldn't, where there are two words that could mean the same thing, you shouldn't interpret them the same way, because that would be redundant. And we shouldn't assume that the drafters of the Bill of Rights would have used redundant language. So I think the right to keep and to bear, they're complementary rights. They're the right to keep a firearm for self-defense and the right to bear arms to carry the firearm. And that's really one of the main issues in this upcoming case in the New York State Rifle and Pistol Association case. What is the limitation on the right to bear arms? Can there be a scheme of may issue? And with
go ahead. Well, there's some interesting comments, and I'm going to get. There are a couple, three that I'm going to string together here that I've never seen this one. So I kind of want to get your take on it. I'm going to start off with this one. John Lloyd Sharf says, as long as habeas corpus is a privilege, no right is meaningful. He followed up with Constitution Article 1, Section 9 calls habeas corpus a privilege. And then he says, final one, what difference does the amendments make if you cannot go to court? That's all over my head a little bit.
Yeah, so I think it's important to remember too that at the time of the founding there was this debate between the Federalists and the Anti-Federalists about whether we really wanted a stronger, more centralized form of government. Okay, and the Federalists didn't support a Bill of Rights because they didn't think that the government had the explicit powers to limit our our rights. Because remember, in the Constitution, it gives the government an enumerated rights, and those rights not given to the government are reserved to the state and to the people, to the states and to the people. And as we've seen over the years, that limitation hasn't really held up. The courts and the legislature have interpreted the Constitution to not be so restrictive. So thankfully, we do have the Bill of Rights. But luckily, they and got these protections of rights. So the Bill of Rights doesn't give us
we're having issues with your microphone, Alex. It sounds like it's maybe coming unplugged or something. I'm getting a lot of scraping sound. Live broadcast, man. What are you going to do? There now. Well, no. Now it's coming back. This is going to be an odd thing. Alex, you want to try logging out and then logging right back into your browser window? And I'll try doing a short monologue while we're waiting for you to get back in. I'm hoping that will clear things up. There goes away the audio problem as he logs out. And I'm hoping once he logs back in that that will clear up the issue we have with his audio. I very much apologize for this. And I hope we get this settled out real soon, although we are near the bottom of the hour anyway. So, and I do notice I'm on my left here, as you see me looking over this direction. When I'm looking over this direction, I'm looking at, we got you back, Alex, and how's your audio?
Can you hear me okay?
And I hear a little bit of the audio. I'm going to call it an artifact. I hear a little bit of it in the background, but it's not nearly as bad as it became at the end.
Okay. You can deal. I'm sorry to interrupt. Were you in the middle of things?
No. And here's that audio problem again. I don't know. It sounds like somebody's rubbing your microphone. I don't know. I don't know what the deal is. But wow. But what I'm noticing is it's happening when there's other audio coming through. So it's a technical issue. I think it's going to take longer than we have to sort out. So, but we are coming up on the bottom of the hour. I'm hoping if I shut up that I can give you long enough. If we got about a minute and a half, if you want to try to sum up in that minute and a half what we should take out of the Heller decision.
Yeah, so the Heller decision said that we have an individual right, not a collective right, to keep their arms. It was extended through McDonald to say that right applied to not only the federal government but also to the states. And now we're with the Brewett decision, the New York State Rifle Association case in New York, and the Brewett decision. So this is the first case at the Supreme Court since Heller and McDonald to recognize that, or to say that states can't infringe on the right to keep and bear arms. It's like we talked about early on in the broadcast. It's a right that shall not be infringed, and these may issue licensing restrictions that states have simply don't meet the muster, don't support our Second Amendment right to keep and bear arms.
I even muted myself, hoping to not create that feedback. But well, we are just now coming up on the bottom of the hour. Alex, I apologize for the technical difficulties, but thanks for joining me today, man.
Yeah, thanks for having me, Paul.
Next Friday, well, last time we had technical issues, we were talking about, forgive me, my brain just took a vacation. We were talking about the
Qualified immunity.
Qualified immunity. Do we want to maybe take another crack at that next week? It's been several weeks, but that show was significantly shortened by technical difficulties. We want to see if we can maybe take another shot at that next week.
Yeah, perfect. That works for me.
All right. And, well, that all depends, I guess, on what happens on Wednesday and how big the explosion is on Wednesday at the Supreme Court. All right. Well, everybody, thanks for putting up with us. Thanks for watching. Thanks for commenting. There's been great comments coming through, even through the technical difficulties. And come join us next week, Monday through Friday, 5 p.m. Central Time, for more Daily Bullet. Thanks for watching.